Thanks for stopping by for this week's 2 Minutes with Tim. Remember, you can follow past editions of 2 Minutes with Tim on timvanronselen.com. I want to change tradition this week and talk about a business litigation matter that we see besides just personal injury. And I want to talk this week about non-compete agreements. Non-compete agreements are frequently signed by employees shortly after starting work with their new employer. They're frequently given to employees along with W-2 information and I-9 information, and they're usually told just sign here, and people sign them without giving much thought to them. I hope this week I can talk about it a little bit such that you might give some thought to it before you ever are willing to sign a non-compete agreement. I want you to know what those are. Non-compete agreements are meant to keep an employee from competing against a prior employer for a number of years or a time period in addition to a certain geographic scope. Most non-compete agreements go for about 2 years, and they often have anywhere from 90 to 200 miles of a scope that would keep you from competing against your private employer during that time period and within that geographic area. Non-compete agreements used to be limited to high-income individuals who had significant education and training and were given private information regarding customer lists or payroll information or price information that employers didn't want being shared with its competitors. These days, non-compete agreements are used in a much broader setting. The best studies show that currently about 38% of the American workforce has signed a non-compete agreement at one time, and 18% of the American workforce is currently under the protection or the restriction, depending on how you want to look at it, of a non-compete agreement. Non-compete agreements are also now being used in low-wage situations. There's been a lot of litigation and cases involving places like Jimmy John's, which is somewhat famous for having their employees sign a non-compete agreement. That's generally thought that they're using that to artificially keep wages too low and to keep their employees from going to other fast food restaurants. There's been legislation in a number of states to outlaw or limit the use of non-compete agreements for individuals making around $14 an hour or less. The next time you are getting a new job or are asked to sign a non-compete agreement, slow down, read it carefully, and know that that can significantly impact your ability to leave and go to work for a competitor. If you have questions about a non-compete agreement, feel free to give me a call, 635-7977. Thanks for stopping by.